Good morning. Welcome back to our last case for today's docket. It's going to be Mark Bossack versus People Trust Insurance Company. It's case number 23-325. I'll remind you that our argument today is going to be live streamed on YouTube. Again, the appellant and the appellee will each have 20 minutes. We typically reserve 5 minutes for rebuttal, but if you would like a different amount of time, please let us know. Oh, I'm so sorry. Thank you so much, Judge Lambert. My name is Judge Nardella. I have joining me Judge Lambert again, and we also have a new judge joining us today. And we thank you for your time, Judge Jared Smith. So whenever you're ready, counsel.
Thank you. Good morning, and may it please the court. My name is Christy Hatcherbowl, and together with Todd Pittenger, I represent Mr. Bossack, the appellant in this case. Mr. Bossack has, in the trial court, now in this court, has sought to either vacate or modify the arbitration award. And as far as vacature is concerned, the statute says that the court shall vacate an award when the arbitrator exceeds his powers. And in this case, we argue there are two grounds that show that the arbitrator exceeded his powers. The first is that the arbitrator took up an issue that was not submitted to him when he interpreted the phrase legal proceedings. That was not an unresolved claim or controversy, and that's what the arbitrator is charged with adjudicating.
Wasn't he being asked to award attorney fees?
Yes, Your Honor, and there is a distinction here. Both parties claimed attorney's fees. That's very clear. It was not unresolved, however, that the phrase legal proceedings, that wasn't an unresolved issue. It wasn't a claim between the parties. There was actually no dispute between the parties because essentially the only dispute resolution mechanism that they could avail themselves of is arbitration. And so both parties submitted that legal proceedings would include arbitration. And he skirted basically the issue of deciding, the issue that he was charged with deciding, and that would be prevailing party, and instead simply said, it doesn't apply.
What if he just said, okay, I don't want to, I'm just going to not award fees. Under Florida law, I find that neither party is entitled to fees. Have a nice day. Here's my ruling.
I have to say that had he done that, then FIE's argument would be persuasive, but that's not what he did. He instead said legal proceedings does not include arbitration. And so basically he threw out section 6.17 of the contract. And as
he made an error of law?
That's actually an error in the extent of his jurisdiction. Because again, we go back to what—
He had jurisdiction to award fees.
He had jurisdiction to award fees. But if you look at what section 6.16 says as far as arbitration, the dispute resolution mechanism, it says that unresolved claims or controversies are to be subjected to or submitted to arbitration. And again, this was not a dispute between the parties. The parties sought attorney's fees because they anticipated that the prevailing party would be allowed to or would be awarded attorney's fees in the arbitration provision, because again, it's the only way they can actually enforce the agreement. So it is a distinction, I get that, but again, he skirted the issue of deciding whether there was a prevailing party or perhaps no prevailing party.
That's what I say. He could have set up one side won one issue, one side won the other. I think it's a wash. Everybody go home, pay your own fees. Very interesting case. Have a nice day.
Right, and I agree with that, Your Honor, but instead he resolved something that nobody disputed. And that's the issue of the attorney's fees. We also claim that there's a basis for vacature because he failed to follow Florida law, and under section 6.4 of the agreement is governed by Florida law.
Didn't he say he was following Florida law? Didn't he speak that or write that? And under Florida law, I find there's no compensable damages because it's too speculative.
He said that under Florida law, but the thing about it, he did make that comment. I get that. Okay. However, under Florida law, we have two problems with that. Under Florida law, where a party has suffered a breach of contract, as long as the innocent party in that case is entitled to an award of damages unless there's absolutely no evidence whatsoever of damages.
Well,
And
let me throw out a hypothetical. Let's make it a little, this is very very difficult litigation, very interesting stuff, but let's make it easy. I have a promissory note that says anytime there's a breach, you have to go to arbitration. You don't get to sue. So party A sues, goes to arbitration against party B saying, I loaned you $1 million and you didn't pay me. And so the arbitrator says, okie doke, I listened to it. You're right. You didn't pay him, but I find there's no damages because I just do. Well, that may be quite a problem. I decided that the damages have not been proven. And we might say, well, that's completely wrong. How does that get reversed in arbitration? How does that get reversed when the arbitrator makes an error of law and not awarding damages that are proven?
I understand that, you're saying that he did say he followed Florida law. I get that. However, though, the arbitration agreement says Florida law has to be followed.
Okay, well, how about my hypothetical? My arbitrator right there, I think Florida law says if I prove that you signed a note, I have the original note, you didn't pay me, and you admit during the course of the arbitration that I didn't pay you, and the arbitrator says I find in favor of the plaintiff, but I award no damages under Florida law, that I guess in the court of law we would say that's not a good call. But can't the arbitrator do that, and that's an error of law that we can't touch?
I think under certain circumstances it may be. However, but in this case it wasn't. He had substantial, if you look at the case law, he had substantial evidence before him of damages.
And he erred.
And he erred in that.
It's a matter of law.
But he still had to follow Florida law with respect to.
But he says, I'm following Florida law and I just err, just like trial judges occasionally err, I guess.
I understand that, but at least if you look at the visiting nurses case, and they talked about, if an agreement had basically directed that an arbitrator follow a certain law, a state's law, and he didn't, that case stood for the proposition. Well, actually, they were citing another case, but visiting nurse said that would stand for the proposition that where an arbitrator is directed to follow a state's law and they don't, that actually could constitute an act in excess of his authority, because you have to look at authority as it's governed by the contract. And the contract here said you got to follow Florida law. Florida law says that if you have a breach, the innocent party is entitled to damages unless there's an absolute failure of proof of those damages, or unless they preside or they go forward under an invalid theory of damages.
Well, didn't the People's Trust Insurance Company's expert opine that your client suffered no damage?
I'm sorry, and I just want to clarify, it's actually B2FIE is the appellee.
Why does this say People's Trust on my? Did you do this, Molly?
I'm sure it's me.
All right.
I apologize, but yes, it's B2FIE and Concar.
You're right, it is. I'm not sure. Why does it say that? All right, go ahead.
Okay.
My bad.
All we're saying here is that where the agreement actually says you've got to follow Florida law and they fail to do it, that would be an act in excess of their jurisdiction. And in our case, we say it's both a damages issue as well as an issue with the attorney's fees. Again, we go back to the point that they should have never taken up, or the arbitrator should have never taken up this issue of what legal proceedings meant, because it wasn't an unresolved claim or controversy that the parties actually submitted. You could see that by virtue of the fact that both parties sought fees. Why? Because arbitration was the only dispute resolution mechanism that is available to them. And by basically he exceeded his jurisdiction essentially by deciding an issue that was not unresolved, that was not submitted to him. His job basically was to essentially determine whether or not there was a prevailing party, if any prevailing party. And again, like I said, if that had been what he had done, I would find Appley's argument persuasive, but instead he took a step forward and did something more than what he was charged with doing. I liken this to the Nash case that we cite in our brief. In that case, the university was charged with basically construing an application for tenure in accordance with what the CBA spelled out for criteria for tenure. The allegation by the employee is that, look, when you were evaluating me for tenure, you didn't follow those instructions. And so when it went to arbitration, the arbitrator said, yeah, the university violated the CBA. It was supposed to follow these criteria. It didn't. But then the arbitrator went a step further and said, not only did you breach the CBA, but you have to go and you have to actually promote the employee. And the appellate court ultimately, and I think the trial court, the trial court got it right, I believe, and it was affirmed on appeal, if I'm remembering correctly. But they said, look, it was a breach of basically the arbitrator's jurisdiction when they went one step further and not only said there was a breach of the CBA, but that you actually had to promote her because under the agreement that governed the CBA, that was a decision that was only left to the administrator. In this case, the arbitrator was charged with basically adjudicating unresolved claims or controversies. What legal proceedings meant was not a claim or controversy. It was undisputed. Nobody disputed that the prevailing party in the arbitration proceeding would be entitled to their attorney's fees, so long as there was a finding of a prevailing party. But again, he went one step forward by deciding that, and then he also did so contrary to Florida law, which the contract also says governs, and that says under Florida law that basically arbitration is included in things such as legal action.
What if the arbitrator just said, didn't make a finding as to who was the prevailing party and just said, all right, I'm at the end of I'm checking off my list of things I got to rule on, no attorney fees. I find that nobody should be awarded fees, and signs off on the arbitration award. Doesn't make a prevailing party finding. Is your argument the same, that he's not following Florida law, therefore it's reversible?
I think under that's not our case. I think under that situation,
I
know, I get it.
I get hypotheticals of that because it's not the case.
I get it. And I think under that situation, we would not actually know why he didn't decide that anybody was entitled to it. He just basically says nobody's entitled to attorney's fees. He didn't do that in this case,
well,
though.
Let's say he did. I'm curious as to the answer to that. I'm trying to figure out the bounds of what we can and cannot do regarding the arbitrator's decision here.
Well, because in this case, in your hypothetical.
Yeah, my hypothetical. Let me understand my hypothetical first, and then we can morph into this.
In your hypothetical, where he gave no explanation, he just says no attorney's fees. I would have to agree that in that case, there would be no way for us to know.
You'd agree with me on that one.
I would agree with you on that one. I would agree with you on that one. But in our case, he actually explained why he wasn't awarding fees. He said this doesn't apply.
So in other words, he said, well, under Missouri law, I find no fees for you. Then you'd say, look what he just said. He applied the wrong law. You exceeded jurisdiction because we contractually agreed that you'd apply Florida law, and you just opened your mouth and said Missouri law for something. That would make it easier for you.
That would make it easier.
In between those, right?
That would make it easier, although that's a little bit of a different issue. And the only reason I'm saying that is because with respect to the first claim about the attorney's fees, again, it's because it's not an unresolved claim or controversy. It was not submitted to him. But then the second part of that is that he likewise did not follow Florida law. Now, and there's two different arguments, because obviously in our case, in your hypothetical, we wouldn't know why he exactly denied attorney's fees. And I get that. And that would be a harder one to do. But here, the award itself, he basically says, this doesn't apply. This doesn't apply because legal proceedings don't include arbitration. So it's like, well, that wasn't an issue submitted to you, arbitrator. We only submitted to you unresolved claims. The unresolved claim is not whether or not legal proceedings includes arbitration. The unresolved claim or controversy is who is going to prevail in this case? Who breached the contract? Are there damages? And third, is there a prevailing party? But it's not what that particular provision means.
Did you guys go back to the arbitrator and say, hey, you're construing something we didn't ask you to construe, and what did the arbitrator say?
The arbitrator very curtly said that he did not have authority to correct the award under, I think it was JAMS Rule 24J. He basically said this is not a mistake of a calculation. And he said, that's what I'm limited to. And so that was the ruling on that. Because he was obviously constrained by JAMS rules, whereas obviously this court is not. I also wanted to discuss the fact that another claim that we have is modification. And that basically concerns the evident mistake in the description of the thing or property referenced in the award, and that is ComCar. I will tell you that I have looked and looked and looked, and there's not case law in Florida, and I couldn't find it elsewhere explaining exactly what this is. But essentially, an evident mistake in the description. Well, what is a description? It's basically the salient features of the item, the property, the thing. Here, in the award, he basically said that as of the date of closing, and nobody disagreed, that the damages would be the value of ComCar on the date of closing. What would ComCar be worth if it had not been, if the buyback provision had not been breached? And so in his award, he erroneously describes the company, ComCar, as being shorn of 2 of its 4 divisions. He basically says it'd be less than half of the company it was.
Counsel, doesn't that seem like it's a mistake in the value of the thing and not the description? The description seems to me to be, if you were to describe a piece of property and you were to give it the wrong address, or you were to give the company the wrong name and to say that it transfers ownership. That's how I read it. Can you address that?
Yes, absolutely. I think that they're not mutually exclusive. Okay, so what is the value of a company? What is the value of a piece of land? It's made up of what are its salient features. So for example, with a piece of property, if you described a piece of property as being 2 acres when it's actually 50 acres, that is a mistake in the description of the thing at issue in the award, but it likewise has an effect on the value of the property. Well, here we're dealing with the company. What is the value of a company? It's made up of what are its assets? What are its operating assets? In this case, the 4 divisions of the trucking company, as well as the non-operating assets, which consisted mostly of real estate that ComCar held. And in this case, the evident mistake is when he described it as being without 2 of its 4 divisions. He basically said it's gonna be reduced to less than half of the company that it was pre-closing. And that is where there is an evident mistake in the description. And of course, it has a direct impact on the value. That is, I mean, I don't think you can, you're gonna have a hard time changing those around. And it's also, again, it's a mistake, a factual mistake, but the 2 are not mutually exclusive. And I understand that that is the argument that appellees have made, that this is just a mistake in fact. But a mistake in fact can also be a mistake an evident mistake in the description of the thing at issue in the award.
Didn't he not award damages because he found it too speculative? So what's the difference if there was 3 divisions or 2 divisions remaining?
Well, I get that he did find that they were speculative. He still had a mistake though in the description. And I guess my point is we have this statute here. That is a ground for modification. It has to mean something. Courts are required to read statutes to give effect to each provision. And if mistaking the company's divisions and saying it would have been reduced to half when that's not actually what the company was going to be reduced to as of the closing, that constitutes an evident mistake in the description of the thing.
But how does that affect his ruling of it's speculative, whether it was 2 or 3? That's what I'm, we're supposed to be very deferential. The height,
Correct.
The height is, don't touch arbitrators' decisions. They have some very limited specific things. He says this is the reason I found this. Whether he put the wrong name on something or had too many divisions or not, he still thought it was speculative. He didn't say one word. That wasn't the factor in his decision. It would sound like.
I understand that, but it was still something. It was at the heart of his award. What does ComCar consist of? And again, I think that statute has to have some meaning.
So if he said there are 3 divisions left, but it's still too speculative for me to award damages, therefore I award Mr. Bostic 0 damages, then I guess if I'm following your argument, that would be kind of a leg out of the table. Your argument is kind of weakened then, right?
It may be, but the problem is the statute doesn't exactly say how you get there, but if there is an evident mistake, the court under the statute is supposed to modify or correct it.
Would it be named, he used the wrong name for Mr. Bostic? That's an evident mistake.
But that is not the thing referenced in the award, okay? So for example, if he makes a mistake as far as a witness and what the witness said, unless it went to the description of the property or the thing referenced in the award, that would just be a factual mistake that would not be subject to modification. And I do understand your point as far as like, how do we get from, a modification, or how do we get to this mistake to the valuation? And I understand that is basically an unresolved issue.
We're not supposed to comb the record to determine.
No, you're not, and you don't have to, because essentially in this case, a correction would be, a remand back to the trial court to basically grant damages in the lowest amount of which there was evidence by FIE's own expert saying that regardless of what happened and what the value of Comcar was worth, had they not breached, he would have gotten a company that would have held over $10 million in non-operating assets. He would have gotten 90% of that. Those non-operating assets are land. He would have had Comcar, he would have owned a company that had almost $10 million in land. And so that is.
He erred.
He did err, but he did so by basically making an evident mistake in the description of the company at issue.
Counsel, you're into your rebuttal time.
And I will reserve the remaining time for rebuttal. Thank you.
Morning, may it please the court. I'm Steve Sen, Peterson Myers here for the appellees. Here at council table is Elizabeth Morris at the Latham Watkins firm, and also here and present in the courtroom and on the brief is my law partner, Bob Peterbaum. As has been noted, arbitration is a favored means of dispute resolution. Courts indulge every reasonable presumption to uphold proceedings resulting in an award. We cited the Roe v. Amica case for that, but there's a lot of other cases that say the same thing. Parties agree to arbitration in order to limit the expense and the delay of court litigation and the appeals. Here we are nearly 3 years after the arbitration, so clearly.
Let me ask you my hypothetical.
Certainly.
Let's see how your answer is. All right, so we're suing on a note. We're forced to go to arbitration. It's $1 million note. Person holding the note says, that person over there, the defendant, has never paid on the note. It was due on such and such a date. Here's the original note. I'm the owner. Make it even easier. I'm the lender on the note, so I'm the original maker of the note, and here we are. And arbitrator says, yep, sounds like a breach. I award no damages under Florida law. Have a nice day. Everybody scratches their head except especially the guy who's got the note saying, where did that go wrong?
Yeah.
And he said, well, that must be able to be fixable because even those, certainly a trial court will get it right, but if we can't get the trial court to get it right, those geniuses under 6DC will fix it. And why wouldn't you then be losing that fight even though it seems like you should have won? Because the arbitrators made a decision to apply Florida law incorrectly, but you all decided to roll the dice with that person who's the arbitrator.
Your Honor, that sounds like a mistake of law to me. And the courts have since.
So you as the holder of the note would just be out of luck there under that because the arbitrator went awry in his or her interpretation of Florida law.
The question is one of the authority of the courts.
Which, I mean, it's the authority. The arbitrator obviously had the authority to make that decision, just made it clearly wrong. Didn't apply Alaska law, thought the Florida law said, well, for whatever reason, you don't get any money on this note that's been breached.
Yeah.
And you lose, and that's just, you're kind of dead in the water, aren't you?
The question.
Lack of a better legal term, but you're kind of dead in the water.
The party that got zero damages would be dead in the water because what you are describing does not fit into any of the categories specified by the Florida Arbitration Code allowing judicial review of the arbitration award. If they just come in and say this is a miscarriage of justice and that arbitrator didn't know what he was talking about, and obviously under Florida law we should have gotten damages, well, look at the Florida Arbitration Code and none of those arguments fit as providing a basis for judicial review.
So is that analogizing to this case? Your opponent says, not for nothing. There's nothing speculative about there's hard assets here. There's $10 million of assets here. So regardless of the value of the business or what have you, I should have got 90% of that $10 million building, which would be $9 million, and that's clearly wrong, and I should win, at least as to that. And that, therefore, I guess the arbitrator exceeded his authority or something?
Well, that is the argument here, that they should have gotten at least that, what they present as a minimum value. Multiple problems with that argument. The first argument is, once again, it's an argument about a error by the arbitrator that does not fit within any of the grounds. They're not claiming the arbitrator was corrupt. They're not claiming the arbitrator was not partial. They're not raising any of the issues that fit squarely within the provisions. They're citing to a couple of provisions, and it doesn't fit there. But even aside from that, as the arbitrator noted, and his award's part of the record, they had to pay $57 million for these shares. And so there would only be damages if what they got after that transaction was more than $57 million. And the arbitrator, they didn't just grab somebody off the street. This was a 20-year federal judge who had spent 7 years in the trial court in Illinois. He listened to 6 days of evidence, hundreds of exhibits, almost 200 pages of briefing. And he said, under Florida law, you only get damages if you're going to be better off after the transaction that you could not close. And you would only be better off if the value of those 90% of Comcar shares is greater than $57 million. And if you pay $57 million and get back $10 million, guess what? You have no damages. You're better off not having closed that transaction. And so the arbitrator was 100% in finding that, absent proof that the company on the other side of the transaction was worth more than the consideration they would be required to pay, then there were no damages. And he had 2 experts on this issue, plus additional evidence as to what those shares were worth. And he considered all of that evidence. He had separate briefing on the damages issue, and he addressed that in his award and found that the evidence simply did not satisfy Mr. Bostic's burden of proof.
Your opposing counsel seems to argue, or unless I misinterpreted that, the arbitrator did not apply Florida law in evaluating and then awarding no damages. Can you speak to that?
Well, there's absolutely nothing in the record that would suggest that. The briefing all was assuming Florida law. His award says that he is doing it under Florida law. He's not citing Alaska cases. He's not citing Wisconsin cases. And he handled the case appropriately under Florida law. For example, this issue of attorney's fees and whether he acted outside his authority in granting attorney's fees. He was doing exactly what the Florida statute required him to do when he's faced with a motion for attorney's fees. And this is in 682.11.2, Florida Arbitration Code. An arbitrator may award reasonable attorney's fees and other reasonable expenses of arbitration if such an award is authorized by law in a civil action or by the agreement of the parties to the arbitration proceeding. So any arbitrator acting under Florida law is not permitted to grant attorney's fees unless he is satisfied that they are authorized either by Florida law or by the agreement of the parties.
So, counsel, if I may,
yes, sir.
And I'm sure you all are very familiar with the visiting nurse case for Supreme Court. In that case, they cite the Stolt-Nielsen case.
Okay.
The Stolt-Nielsen case, parties had stipulated to one thing, which had to do with the class action, whether or not this particular dispute was something that could be submitted to class arbitration. The arbitrator went the opposite direction of the party stipulation, and the court said that was outside the authority. Our Supreme Court seems to say that's right. That's a right decision for that arbitrator to be overturned, to be vacated, because they went outside the party stipulation. The opposing counsel has argued that because you both were asking for attorney's fees, effectively you both stipulated to attorney's fees. So how can you stand here today and say, well, no, we really weren't asking for attorney's fees because we didn't believe we could get them? How could you be asking for them? They're asking for them, and for this court not to say, well, that's effectively a stipulation. Are we now within the Stolt versus Nielsen decision, Stolt-Nielsen decision?
Yeah, I'm not sure that the fact that both sides are asking for attorney's fees allows the arbitrator to set aside his obligation under the Florida statute to confirm that there is a basis
But
for them.
is it in controversy?
But if they had agreed, and if they had formally stipulated to the arbitrator, we agree that you should award attorney's fees to whoever prevails in this case, then we might be closer to that decision. There was no agreement at any point by my clients that Mr. Bostic should recover attorney's fees. And another issue on the attorney's fees issue, while we're on it, that
Well, let me follow up that there.
Yes,
So, but I mean, were either of you disputing? I mean, your arbitration clause states any unresolved controversy or claim arising out of or relating to this agreement. Did either of you believe it was an unresolved controversy or claim that attorney's fees could not be sought in an arbitration proceeding? Was that truly in controversy? This is my problem is, are we now falling within the one exception that I think could potentially be applicable here, which is outside of the authority of the arbitrator, something not submitted to the arbitrator? Tell me how the record shows that the question of whether fees in an arbitration, that was an unresolved claim or controversy that the arbitrator was even supposed to be considering.
Well, certainly it is correct that my client, counsel for my client, did not make the argument that the prevailing party should not get attorney's fees during the arbitration proceeding. It is correct that the arbitrator reached that decision sua sponte and without the argument being raised. However, he looked at the Florida Arbitration Code and saw the provision that required him to do that. There was no stipulation between the parties on that issue. And so the question then becomes, is there a way to fit that within the exceeds the jurisdiction of the arbitrator provision for allowing the award to be vacated? And that provision is only considers, and I'm referring to the Schnurmacher-Holt case as well as the visiting nurses case, that provision only considers whether the arbitrator has gone beyond the authority granted by the parties or the operative documents to decide an issue not pertinent to the resolution of the issues submitted to the arbitration. So was it pertinent for him to consider whether the language of the arbitration agreement provided for attorney's fees in the course of arbitration as opposed to what the arbitrator deemed to be legal fees? I think that is a pertinent factor for him to decision, especially since Florida law says he's supposed to.
Okay, well, let's look at that visiting nurse case. So, I mean, in quoting the Stolt-Nielsen decision, the quote the Florida Supreme Court uses is, the stipulation left no room for an inquiry regarding the party's intent. And my question is, based on our record, what room is left for an inquiry that arbitration is not something that fees are available for, in that you requested them, they requested them, no one disputed that arbitration was not the type of proceeding that fees could be rewarded. How do we have any room for inquiry as an appellate court as we're looking at this? Show me in the tell me how we can find some room for an inquiry here. So if we can, that's great. But that's what I'm struggling. I'm struggling finding any room for an inquiry as to whether or not both parties were of the understanding and had not submitted this issue to the arbitrator as to whether arbitration itself is something you could seek legal fees for.
Well, I think the arbitrator is required under the Florida Arbitration Code to stick within his authority. And that involves looking at Florida law to determine the extent of that authority. Just like a trial judge can sua sponte recognize their own jurisdiction, I believe an arbitrator should sua sponte recognize his own jurisdiction. If somebody gets up and asks for something that's clearly not appropriate under the arbitration agreement, whether the other side objects or not, I think it's entirely appropriate for the arbitrator to say, wait a minute here, let me see what the agreement of the parties is. Let me see what the Florida statute calls for. And if they're asking for something that is outside the scope of my authority under the Florida Arbitration Code, I'm not going to do it whether there's an objection or not. I think it's appropriate for a trial judge to do that. And I think it's certainly appropriate for an arbitrator to do that as well. And ultimately, it comes down to the question of, did he exceed his authority in considering whether he had the authority? And I don't think the Stolt case stands for that, where there was an agreement as to what the provision meant in a formal stipulation. There's nothing like that in the record here. And because it does go to the arbitrator's jurisdiction, I'm not sure even if there was, and the statute speaks very clearly to this point. The arbitrator may grant fees if and only if there is a basis in the contract or under Florida law. And so when he takes a close look and interprets the agreement, what's he doing? He's interpreting an agreement in order to do something that he is required to do by the statute. Do I have authority to do that? That is going to boil down to an alleged mistake of law or fact in its interpretation of agreement, and it is not subject to judicial review. As was said before, you are not, arbitration proceedings are designed to be less expensive, not have interminable appeals, and for that reason, the courts do not comb through the record. Having said that, the order of the circuit court indicated that he had combed through the volumes that were presented and did not find a basis for any of the grounds that satisfied the Florida Arbitration Code. This court's review is even more circumscribed than what the circuit court did. Was there error by the circuit court in confirming the award? Because none of the issues that have been raised fit within the grounds of the Florida Arbitration Code for setting aside or modifying, then the thing should be affirmed. I do want to speak to the issue of evident miscalculation and the argument that was been raised. I mean, that certainly 682.14. There is an interpretation of that provision in the Glenn Johnson versus Ruzicka case, which is 1987 second DCA opinion, where the court found that should not extend where the argument contends that the arbitrator in calculating damages was improperly affected by a wrong view of the evidence. Otherwise, any kind, and this is a gloss, but otherwise, any kind of argument about an arbitrator's damages decision might be raised as a miscalculation. You would, if you open the door to he got the damages wrong because he didn't consider this or that about the value of our harm, then you're going to open the door to judicial review of just about any kind of damages thing. That's an exception that would very quickly swallow the rule on limited judicial review of arbitration. Glenn Johnson shows that if the challenge to the award involves how the arbitrator viewed the evidence with regard to damages, this is not the kind of evident miscalculation that section 682.141A might reach. This was not a perfunctory affair in the arbitration proceedings. It was extensively litigated. The arbitrator, as I mentioned, very well-credentialed person. There are over 50,000 pages of documentary discovery, multiple pre-hearing depositions, exchanges of expert reports, 6 days of arbitration, over 32 hours of witness testimony, 227 exhibits, and nearly 200 pages of briefing. And the arbitrator made his award based upon the issues that were presented. He did not exceed his authority. He was not corrupt. He did not do any of the things that are a basis for setting aside the award. And frankly, my clients weren't delighted with the award either. Lost on some issues that we think he was obviously wrong on. But we respected the authority of the arbitrator as acting within the scope of his authority under the agreement, within the scope of his authority under the Florida Arbitration Award to do what he did. There was no basis for, no legally sufficient basis for our side to complain. We paid the damages awarded for wrongful termination. Mr. Bostic accepted that. He's accepting the parts of the arbitration award he likes and complaining about the parts of the arbitration award he doesn't like. And that's not how it's supposed to go under the Florida Arbitration Code. The arbitrator did what he was supposed to do. He had abundant review of the evidence. The evidence supported his findings, whether my side likes it or not, and whether Mr. Bostic's side likes it or not. And we ask that the decision of the circuit court confirming the arbitration award to judgment be affirmed by this court. If there are no other questions, I will.
So,
Yes, sir.
yeah, counsel, I wanted just to follow up on the statement that you made. You said that the language of the statute itself creates the room for an inquiry. What language in the statute are you saying creates the room for the inquiry for the court?
I'm referring, Your Honor, there to 682.11.2, where the authority of the arbitrator is specified by statute, and that includes his authority to award attorney's fees. And what it says is an arbitrator may award reasonable attorney's fees if such an award is authorized by law in a civil action or by the agreement of the parties to the arbitration proceeding. So our arbitrator was, following exactly what the Florida statute required him to do when faced with a motion for attorney's fees. Do I have a basis under law or under the agreement of the parties? Now, no one came in and argued against it, but it was certainly pertinent to the issue that was raised because it was pertinent to his jurisdiction. And if he wants to sua sponte decide, am I acting in violation of the Florida Administrative Code by granting this? Well, it's certainly pertinent to the issue of whether fees should be awarded. And because it's pertinent to the issue of whether fees should be awarded and pertinent to his jurisdiction as arbitrator, he did not exceed his authority and was doing, frankly, what exactly he was supposed to do. A final point on that, before I sit down, I'm almost out of time. Harmless error rule applies in this context. And Mr. Bostic, based on the record before this court, was not the prevailing party. He has not suffered any harm here. It was FIE who filed the petition for arbitration. FIE filed that petition asking for a determination that the right to repurchase the shares had expired, and they prevailed on that issue. There was counterclaims by Mr. Bostic to enforce his right to sell. He abandoned that, so that was denied. He asked for damages for breach of his right to repurchase. He lost on that issue, and he only won on the one very small issue of wrongful termination, very small tail on a very large dog. He was not the prevailing party, even if the arbitrator was wrong. I thank the court.
Just quickly, following up on that last point, yes, FIE did file the arbitration.
Does harmless
demand.
error apply?
No, actually, on an order denying a motion to vacate, it's de novo review. And in this case, they filed the arbitration demand. They sought, I don't know how much, but a lot. They wanted basically the cost of doing the due diligence.
It sounds like you're not the prevailing party.
They lost on that. The court found that they actually breached the agreement. It came down then to whether or not there were damages. And I do just want to harken back to this issue on modification. Part of the reason why he had a problem with valuation, and this is found on page 32 and 33, it's actually where he talks about this in his award. The arbitrator says, neither expert addressed the value of the very substantially diminished com car that would have been acquired had he been able to implement his plan to exercise the option. 2 of its 4 divisions would have vanished into other companies. So it was because, in part, that he wasn't able, or that he believed that it was going to be without 2, diminished, it was going to be basically half the company it was, that he made that mistake. And so because he made that evident mistake in the description of the thing at issue in the award, that is also why he found it difficult to value it. However, he flatly rejected their argument that it was worth nothing, because he said, look, you've got a company willing to pay $35 million for simply 1 division, and you've got $10 million in non-operating assets. So we're asking this court to reverse and to either vacate and or modify the award. Thank you.
Thank you both for your arguments and your briefing today. We are adjourned.